Griffins Financial Solutions, achieving your goals together.
Welcome to part one of our webinar on automatic enrolment and the changes to workplace pensions. Thank you for taking the time to attend. We have split the webinar into two parts to make it easier for you to view. What we're going to cover in part one are Griffins Financial Solutions, a little bit about us, overview of automatic enrolment, employer statutory duties under automatic enrolment, then a little bit more in detail about the process that the employer has to go through to satisfy those duties, how we can help, and then some questions from employers which will give you an idea of some of the issues that employers are coming up against. In part two, we'll be looking at making the contributions to a qualifying pension scheme, using postponement, which is a very useful tool for employers to postpone auto-enrolment for up to 3 months, processing opt-outs and opt-ins, record keeping, and importantly failure to comply and the penalties that could be applied to companies that don't meet their duties under auto-enrolment. And again we'll have a series of employer questions. So firstly, a little bit about Griffins Financial Solutions. We are an independent firm of employee benefit consultants and financial advisors. We have offices in Newbury, Reading and London. We are chartered financial planners as a business, and we also provide advice to companies, partnerships and trustees of occupational pension schemes on a comprehensive range of employee benefit solutions, which includes group pensions, group risk insurances, automatic enrolment and workplace pensions, and also employee benefit software to communicate and administer employee benefits, including flexible benefits, and very importantly, looking at the current subject, automatic enrolment compliance. So an overview of automatic enrolment. This is by far the biggest change to workplace pensions in at least 60 years. It's mandatory for employers and employees with some exceptions, such as one-member companies where you'll have a director who owns the business outright and they're the only person involved with the business, and also that you have the opt-out that employees can invoke for auto-enrolment under the statutory legislation. Employers need to budget for the cost of contributions, the initial compliance and also the ongoing administration, because this is not a one-off action. This is something that companies have got to do from their staging date ad infinitum, or until the legislation changes again. So this is not the same as stakeholder pensions. Had quite a few clients say to us, oh, well, it's the same as stakeholder pensions, it's nothing to worry about. Stakeholder pensions have failed miserably as far as the government is concerned. There are lots and lots, in fact thousands, of pension schemes that were set up under the stakeholder legislation that do not have any employer contributions in them. It was not heavily enforced by the pensions regulator. I believe that only one employer was ever fined by the pensions regulator for non-compliance with stakeholder pension legislation, and that was actually a company that contacted the pensions regulator directly. It will be enforced. Some parts of the legislation are written under criminal law, and there are severe penalties for non-compliance. Employers will need advice and guidance for the process starting 12 to 18 months before their staging date. There's a lot involved in automatic enrolment and the duties that have to be carried out by employers to ensure that they comply. It's not something that can be left for 2 or 3 months before their staging date. So we're saying to employers, as is the regulator, that they should be looking at least 12 months before their staging date, larger employers really up to 18 months before staging date. It's not only a pensions issue, this is very much at the heart of business planning going forwards. Now it may appear complex, and as we go through the slides, people may worry that it is quite a complex process. It is time consuming, it will involve companies and businesses with additional administration and compliance, and it could be a little bit more costly, because one is the contributions that have to go into it for those companies that don't have currently pension arrangements, but also the administration that they'll have to carry out on an ongoing basis. Importantly, there are solutions available to make it easier and smoother for employers to administer, and that's where Griffins Financial Solutions can help. So to give people an idea of the scale of automatic enrolment, the larger firms have already auto-enrolled, such as Morrison's, Tesco's, some of the banks and the major retail outlets. However, by early 2014, it's expected that 12 to 13,000 employers will be reaching their staging dates per month. That then drops to 3,000 to 4,000 per month before the 2015 election, and then rises back to about 13,000 per month by June 2015. Now, the reason why I'm mentioning that is to put it into context. UK pension providers, these are the companies that write UK pensions, such as the big pension insurers, establish on average about 13,000 new plans a year. And what we're talking about by early 2014 is 12 to 13,000 per month. Now, the reason why I mention that is that the resources available to employers, the advisors available to employers, and also the pension providers that employers can call on to help them with their pension arrangements. There may be insufficient resources to help employers at that time. So it is worthwhile employers commencing their exercises as early as possible to ensure that they've carried out the reviews of their pension schemes, they've got their processes in place. What are the statutory duties for an employer under automatic enrolment? Well, firstly, they need to provide a qualifying pension scheme for their workers, to automatically enrol all eligible job holders into a qualifying scheme, to pay employer contributions for eligible job holders to the scheme, and to tell those eligible job holders that they have been automatically enrolled and they have the right to opt out if they want to do so. They also have to register with the pensions regulator and give them details of their qualifying schemes and the number of employees that they have automatically enrolled. They'll also have to provide information to the pensions regulator if they are requested to do so. What's the process that employers have to go through? Well, firstly, they have to know when their staging date is. And that's the date from which they have to first auto-enrol eligible job holders into a qualifying pension scheme. They then have to assess their workforce. So they have to identify who to auto-enrol and when they have to auto-enrol those individuals. They have to continuously monitor and assess their workforce. So this is not a one-off exercise. It is something which will happen on a continuous basis and usually on the first day of a new pay reference period. A pay reference period, if a company pays people monthly, will be monthly. If they pay people weekly, it'll be weekly. To provide a qualifying pension scheme for their employees, register with the pensions regulator, make contributions, process opt-outs and joining requests from members, keep accurate records, avoid inducements and prohibitive activity. And a lot of these we will cover later on in part 1 and also some under part 2. But inducements are basically where an employer encourages employees to opt out of the pension scheme. They need to provide their employees with the information about the changes, and there are statutory wording that has to be included in some of the letters and announcements to employees. A little bit more about staging dates. These are based on the number of employees on the payroll as at 1st of April 2012. Now, it doesn't matter if a company has 50 employees on the 1st of April 2012 and may, by the time they reach their staging date, have 200 or 300. It's the number of employees on their payroll as at the 1st of April 2012. There is a concession for small employers who may be part of a larger payroll, and those payrolls that might include pensioners. For example, some employers will have defined benefit final salary schemes where people have retired and have been paid a pension through the company payroll. Staging dates will be phased in from the 1st of October 2012 to 1st of April 2017, with the larger employers first and the smaller employers later on. And then for new employers, it'll be from the 1st of May 2017 to 1st of February 2018. The larger firms have gone in, some of those have already gone in as mentioned, the major retail outlets. Down to the last to go in will be those firms that have less than 30 employees. And their staging dates will be dependent upon the last 2 letters of their PAYE reference number. The pensions regulator wants to encourage employers to get involved and engage with auto-enrolment, and they will be writing to all firms before their staging date, 18 months for the larger firms, and then 12 months and 3 months. Once a company's established their staging date, they then need to assess their workforce. And there are 3 types of employees or workers under the legislation. The first are eligible job holders, and these are aged between 22 and state pension age, earn above £8,105 in the current tax year, 2012-2013, and that's linked to the threshold for earnings under tax, and for 2013-2014 that will increase to £9,440. And this is called the Auto-Enrolment earnings trigger. They work in and ordinarily work in the UK. So eligible job holders are job holders that have to be auto-enrolled into a qualifying pension scheme, and the employer has to make a contribution, at least the minimum statutory contribution, and the employee has to make a contribution. The second category of employee has a little bit more complicated definition, but they're called non-eligible job holders. Now they're individuals who are aged at least 16 and under age 75, earn over 5,564. Now this is the lower threshold for automatic enrolment or qualifying earnings. The 5,564 does not mean a person has to be auto-enrolled, only if their earnings exceed the £8,105. But in this case, a non-eligible job holder is someone earning between the £5,564 and the £8,105. Again, they work in or ordinarily in the UK. Or second definition, they are earning above the £8,105 but are under age 22, or earn above the £8,105 and are above state pension age. Now, non-eligible job holders are not auto-enrolled into a pension scheme, qualifying pension scheme, but they are able to opt in. And if they opt into the pension scheme, the employer has to make a pension contribution, and they have to make a pension contribution, a minimum of the statutory amount. The third type of employee is an entitled worker. And unfortunately, it's an unfortunate name because they're not really entitled to an awful lot. They are aged at least 16 and under age 75, earn £5,564 or less in the current tax year, work in or ordinarily in the UK. They are, however, entitled to join a pension scheme that the employer may have. It doesn't have to be the qualifying pension scheme, so they can join a separate pension scheme the employer may have in place for those workers, but the employer is not required to make a pension contribution to it. However, people can move between these bands, so entitled workers and non-eligible job holders could suddenly become eligible job holders depending on their earnings in a pay reference period or their age. We have to look at the different types of employees that people may have within a business. There may be contract workers, there may be agency workers, there may be overseas workers. That could be people who are seconded from the UK company to an overseas company, for example in the oil industry, or it could be people who are seconded or working from an overseas company for the UK company. Employers will have to assess these people individually to make sure that they are happy that they are either eligible job holders, non-eligible job holders, or they don't have to be assessed for a UK qualifying pension scheme. If we look at agency workers, for example, agency workers might be employed by the company, the business, or they might be employed by the agency. It really depends on who pays them. So if the agency pays them, their contract of employment is with the agency, then the agency will be responsible for the assessment process rather than the company where they're working. What's included in qualifying earnings? We've talked about qualifying earnings very briefly. Now, qualifying earnings are band earnings between 5,564 to a ceiling of 42,475, again for the tax year 2012-2013. Now, in the UK, pension schemes tend to have pensionable earnings, which is usually basic salary. The definition of qualifying earnings for auto-enrolment purposes in the assessment process and the contribution payment process is based on a much wider definition of earnings. So it includes salary, wages, overtime, bonuses, commissions, statutory sick pay, statutory maternity pay, ordinary and additional statutory paternity pay, and statutory adoption pay. So there's a much wider definition there. Also, companies pay allowances. So what happens about some different types of allowances that people might receive? Are they assessed for qualifying earnings? Do they fall outside qualifying earnings? An example of that is car allowances. And this has come up with some of the major companies and larger companies have already auto-enrolled. And it appears to be that some companies, where they provide a car allowance for employees and it's a perk, they have included that car allowance in the definition of qualifying earnings. Where the car allowance has been provided because the employee needs a car to carry out their duties as an employee, then it's been taken outside the scope of qualifying earnings. So from this you can see that employers have to make assessments of what is included and not included within qualifying earnings outside the scope of the statutory definitions. When do employers actually have to assess their workers? Well, firstly, on their staging date. Then on a regular basis for non-eligible and eligible workers. On their re-enrolment date. Now, re-enrolment dates, because employees or eligible job holders can opt out of auto-enrolment, an employer has to re-enroll them again up to a 3-year period. Now, that 3-year period is not a simple 3-year period, and we will cover these in part 2. When a new worker joins service, or on a worker's 16th birthday after the staging date, on a worker's 22nd birthday after the staging date, when they receive an opt-in or joining notice. So you can see it's a fairly complicated process at different stages and different times when an employer has to assess workers. And this is an ongoing process. As mentioned earlier on, it's not a one-off date. This is something employers will have to do continuously. So they continuously assess their workers. So it is prudent for employers to have appropriate compliance software in place to communicate the pension, the value of the pension, communicate the statutory requirements, track and administer the auto-enrolment process, and provide documentation, an audit trail, and provide the regulatory reports that they may have to provide to the pensions regulator. It's not appropriate for employers just to do everything on bits of paper and spreadsheets, as this could lead to a disaster. So a good quality compliant software system that can produce all the necessary information and do the ongoing assessment will make life a lot easier for employers. So once an employer has assessed their workers, they then have to provide a qualifying pension scheme. Now, a qualifying pension scheme can be an existing scheme. If employers have existing schemes, then they can look at those schemes and possibly use those as qualifying arrangements for auto-enrolment. They can establish new scheme or schemes, because typically an employer may in fact have more than one scheme and use different schemes for different categories of employee. They could use the National Employment Savings Trust, known as NEST, or one of the other master trust arrangements, which are alternatives to NEST, or a combination of all these. I mean, in some circumstances where an employer has a lot of casual workers or part-time workers, such as probably in the agricultural industry, then they may have certain workers in NEST or a master trust arrangement, but permanent employees would be in a workplace pension arrangement. The choice will depend very much on their current pension arrangements and the staff demographics. It'll also depend whether they're using the qualifying earnings definition for the contributions or using one of the alternatives under what they call certification for an existing pension scheme. And we'll come on to certification shortly and the options available to employers for existing arrangements. So employers can use more than one pension scheme, and they can use more than one pension provider for different categories of staff. And they can also, within one pension arrangement, use sectionalisation, which are different sections or a lower section for different types and categories of employees. If an employer has an existing pension arrangement, it could be certified as a qualifying scheme for auto-enrolment purposes. Now, if an employer has an existing scheme, they will need to review that pension arrangement for the structure, the eligibility, the definition of pensionable earnings, and the contribution basis. They will also need to look at the charges under that pension scheme, because there are a lot of very old legacy pension schemes on old platforms which may have very high charges, which would not necessarily be appropriate for auto-enrolment purposes. Qualifying schemes have to have a default pension fund, and the DWP and the pensions regulator have given guidance on the types of funds, how they should be structured for auto-enrolment purposes. So again, employers need to review their pension schemes for the default fund. They also need to review the schemes to see whether they're suitable for auto-enrolment. Now, most existing schemes will not be suitable for auto-enrolment. They will have to be amended in some way to allow auto-enrolment. In order to use certification for an existing scheme, there are 4 options available to employers. One of those options is based on qualifying earnings. And unlike the statutory minimum, which is 8% from the 1st of October 2008 total contribution to a pension scheme, including 3% minimum from the employer, depending on the certification route chosen by the employer based on their existing pension scheme structure, it could be 7% total contribution, 8%, 9%. In the case of the 9% certification, the minimum employer contribution is 4%. Or they could simply establish a new scheme for different categories of employees or schemes. If a scheme is certified, it has to be recertified every 18 months. How can we help? Griffins Financial Solutions can help guide employers through the auto-enrolment process. We can make life simpler for employers. We can help them set up suitable implementation and project teams to include the most appropriate people within their businesses. And what we mean by that is that auto-enrolment is not just a pensions issue. It will involve HR, it will involve IT, there may be legal advice required, there will be advisors involved, pension advisors, and there may also be trade unions involved, depending on the size of the employer. So we can help manage that and establish those project teams. We can assess and review existing schemes to see if they're suitable for auto-enrolment. We can advise on suitable schemes as alternatives or sectionalisation of existing schemes. We can advise on salary sacrifice, or what's known now as salary exchange. Now, salary exchange, salary sacrifice will be a very useful tool under auto-enrolment because from the employer's national insurance saving, that could be applied as an extra pension contribution for employees, or some of it could be held back to cover the cost of administration of auto-enrolment and the additional processes that employers may have to have in place. We can establish cost-effective online benefit software systems to ensure that an employer initially and ongoing complies with the legislation. We're going to move on to the questions and some of the questions we receive from existing clients and companies, which will give hopefully some insight to some of the issues that other companies are having to assess. First question we have is we have a number of foreign nationals working in the UK, usually for 6 months, who have been seconded from our German parent company. They are paid by the German company in euros but work in our Reading office whilst in the UK. And the question is, do they have to be auto-enrolled into a qualifying pension scheme? Well, in this particular example, no, because they are not ordinarily working in the UK, they are not paid in sterling, they are not paid by the UK company, and they're expected to return to Germany and the parent company in due course. Other employees, foreign national situations will really depend on these sort of answers, where the employee is paid, where their permanent homes are, and where the contract of employment is. So really the point from this is to understand that these sort of individuals and workers have to be assessed individually and the employer make a decision as to how they treat them. The second question we receive is, if we employ someone on a casual basis, do they have to be auto-enrolled? This will depend very much on terms of their contract of employment and how long they'll be employed for. If they're employed by the company or business and paid by them, they will have to be assessed under auto-enrolment. And it'll depend on whether their qualifying earnings fall within the thresholds of pay reference periods for that particular pay reference period. However, if a company is using postponement, that is one way where a company has casual workers that they can possibly defer auto-enrolling individuals, particularly if they have peaks in their earnings. Are dividends included in qualifying earnings? No, dividends are not classed as earnings under the auto-enrolment legislation. Can we change our current pension scheme if it's not suitable? The answer is yes, they certainly can. An employer can decide to change their pension scheme, close the pension scheme, but what they will need to do is check their contracts of employment to make sure they're not in breach of contract, and to go through the statutory consultation process. And this is where we can help companies assess their existing arrangements and the processes that they need to go through. This is certainly the case with older legacy schemes which may not be appropriate or cannot be amended for qualifying scheme purposes. And any new scheme that's put in place will also need to qualify for automatic enrolment. This is a question that we've had a number of these similar questions to this. At our recent staff meeting, a number of employees asked not to be auto-enrolled. Is this sufficient to comply with the legislation? Well, the answer is no. If they're eligible job holders, they will have to be auto-enrolled, but they can then opt out under the statutory opt-out notice basis within the month. So they will need to receive the opt-out notice containing the statutory information, and that has to be provided by a third party such as the pension provider and not by the employer. So that concludes the first part of our webinar on automatic enrolment. In part 2 we will cover making contributions to the scheme. We will cover postponement, which is a very useful tool for employers, certainly with casual workers. The process of opt-outs and opt-ins, record keeping, and importantly failure to comply, and some of the penalties that could be applied to firms that don't comply with the auto-enrolment legislation. Part 2 will be on our website from 11:30 AM on the 22nd of January 2013. Thank you very much for attending, and if you have any questions or you would like further information, please contact us by emailing us on financialsolutions@griffins.co.uk or by telephoning us on 01635 551 333. Thank you very much.
Griffins Financial Solutions, achieving your goals together.